Hello, my name is Rino Shigeta. I would like to present the matter of Japanese post-colonial issue. It's been almost 80 years since the World War II ended, but it still remains compensation problems and discord with regard to before 1945 matters. Some colonial issues should have been resolved at law, but they have been kept disputed until today. I understand there is no end of suffer of people. However, until when do we have to keep apologizing and paying money for ancestors' fault? And these problems could be set as post-colonial issue of colonizers at Japan. To think about this topic, I would like to introduce issues between Japan and Korea. From now, let's take a brief look at the relationship between Japan and Korea. Is that happening before World War II? And in 1910, Japan annexed Korea and established office of the Governor General of Korea in Seoul. And this is happening after World War II. In 1951, Japan concluded San Francisco Peace Treaty, and 1965, Japan and Korea concluded several treaties, and these two are important ones. Since Korea was Japanese colony, they wasn't at war against Japan, and they didn't have right to join San Francisco Peace Conference. Instead of that conference, Japan and Korea made conclusion of treaty on basic relations between Japan and the Republic of Korea. By this treaty, Japanese colonization on Korea was to put to an end. And these are some extracts from the treaty. Article 2. It is confirmed that all treaties of or agreements concluded between the Empire of Japan and the Empire of Korea on or before August 22, 1910 are already null and void. To establish diplomatic relations, Japan and Korea concluded agreement between Japan and the Republic of Korea concerning the settlement of problems in regard to property and claims and economic cooperation. And this treaty focused on both credit and debt. By this treaty, both credit and debt was liquidated entirely. This treaty is recognized as a foundation for Japan and Korea relationships after World War II, same as Treaty on Basic Relations between Japan and the Republic of Korea. As this treaty is a little complicated, I would like to share outlines of articles in this treaty. If you're willing to read this treaty, please read from the link on the page of related law. Article 1. Japan provide Korea 108 billion yen for free of charge, 72 billion yen for value, but it's long-time low interest rate. And the total amount was about the same as 1.5 trillion national budget in 1965. And please note that the value of yen was of 1965. And these are extracts from Article 2. Japan and Korea confirm problems related to properties of both contracting states and nationals include cooperation. Rights and interests and claim right between both contracting states and nationals are resolved entirely indefinitely. Paragraph 3. Any claims cannot be alleged if those claim rights were based on the matters before August 15, 1945. In this article, Japan and Korea both renounced claim rights of states and nationals mutually. And this is extracts from Article 3. If matters couldn't be resolved through diplomatic channels, Japan and Korea need to respond to arbitration board. From now, I'd like to share the case of wartime labor from perspectives of international law. And what is wartime labor? Wartime laborer is people who worked for coal mines or factories in Japan, especially moved from Japanese colony during World War II. In the beginning, they were assembled by recruitment, and then they were requisitioned since September 1944 based on national mobilization law. This law was adapted to all Japanese, including people in Korea, Taiwan, and Karafuto. Here are incidents related to wartime labor issue. In 1965, Japan and Korea concluded those two treaties, and then in 2005, several Korean wartime laborers brought an action against Nippon Steel in Korea. And in 2009, Korean wartime laborer lost a case in the first and second trials. In 2012, Supreme Court of Korea reversed the judgment in 2009. And then in the next year, Seoul High Court ordered Nippon Steel to pay 100 million won. And then in 2018, Supreme Court of Korea turned down an appeal from Nippon Steel, so the 2013 judgment turned to be final judgment. These are several issues between claims of Japan and Korea's Supreme Court, and these are three main issues related to 2018 judgment. 1. Legality of Japanese colonization in Korea. 2. Range of agreement between Japan and the Republic of Korea concerning the settlement of problems in regard to property and claims in economic cooperation. 3. Arbitration procedure. Issue 1. Legality of Japanese colonization in Korea. Its defendant is Nippon Steel, and which is private sector company, so there is no need to mention legality of Japanese colonization. And in the same case in Japanese court, they didn't mentioning legality of Japanese colonization, but the court founded the fact all Nippon Steel forced claimant to labor for them and all Nippon Steel's liability of tort. However, as old Nippon Steel didn't have same legal identity with Nippon Steel, so the claim was discontinued. Korean Supreme Court claims that wartime labor was directly connected to Japanese illegal colonization. As Japan educated Korean people to obey to Emperor of Japan, this consciousness led Koreans to join wartime labor without well understanding. And at the same time, Koreans didn't have choice to resist even if there is no compulsion. They claims another things, that is, Korea and Japan didn't make an agreement toward legality of colonization. If the colonization was illegal, Japan had no right to educate people to obey the Emperor of Japan. So, what Korean Supreme Court wants to claim is Japan made an illegal education on Korean people, so they joined unthinkingly wartime labor. That means wartime labor could be illegal labor. Issue 2. Range of agreement between Japan and the Republic of Korea concerning the settlement of problems in regard to property and claims in economic cooperation. Korean Supreme Court claims Korea only waived right of diplomatic protection, and individual nationals' claim rights are remaining. And also, issues didn't argue in 1965 is out of treaty's range. But these could be said as problems of interpreting law. Issue 3. Arbitration procedure. In 2019, Japan transmitted the notification and statement of claim to the Republic of Korea and invoked the arbitration clause in the agreement. But Korea didn't follow the procedure set forth in Article 3 of the agreement and failed to comply with its obligation to appoint an arbitrator, and also to choose a third country, the government of which is to appoint an arbitrator for the contracting party within the period provided for in the agreement. The behavior Korea took is illegal as they didn't follow the articles in treaty which they made agreement. For consideration, these problems are interpreting law. So Korea and Japan is necessary to have the third party's judgment. And Korea has a legal duty to join arbitration clause So didn't comply with Japanese request is completely illegal. And there is a phrase in law, pacta sunt servanda. This means once made an agreement, contracting parties must follow its articles. And for my questions, how long will Japan and Korea keep clinging to same issues? As 18 years are coming to pass from the end of World War II, we have to go for another steps to make each other's more enriched and better company each other. These are related laws and references. Thank you for watching my presentation.